Hi, my name is Jamal Barnes and I'm a lecturer in the School of Arts and Humanities at Edith Cowan University in Perth, Western Australia. This is a short presentation based upon an article that I recently published in Review of International Studies called Torturous Journeys, Cruelty, International Law and Pushbacks and Pullbacks over the Mediterranean Sea. Before I begin, I would like to acknowledge the traditional custodians on the land on which I meet today and pay my respects to elders past and present. I would also like to thank the editors and anonymous reviewers at Review of International Studies for their very helpful and constructive feedback. I have several main arguments in this piece. My first main argument is that the migration deterrence policies of European actors, and I focus in particular in the article on Italy, but also the European Union more broadly, and in particular I focus on the policies of pushbacks and pullbacks, is that pushbacks and pullbacks are exacerbating the vulnerability of migrants and refugees to torture and ill treatment. As migrants and refugees are pushed and pulled back into Libya, they are subjected to inhumane detention, ill treatment, and often, as I show in the article, torture as well. I argue that the vulnerability of migrants and refugees is not something that is natural or inevitable, but rather it's constructed through these European policies. And in particular, as states engage in what's called legal evasion, where they strategically use and interpret international law to minimize their obligations, as well as undermine human rights protections, this practice of illegal evasion actually has what's called distributive effects, whereby by stripping away human rights protections, migrants and refugees become more vulnerable to things like torture and ill treatment. So looking at and focusing on the distributive effects of this legal evasion can help shed important light on how states can engage in cruelty in particular from a distance. And finally, this use of legal evasion to enable and justify pushbacks and pullbacks is creating an indifference to human suffering. As legal responsibility is being denied, the refugees and migrants are being excluded from moral concern. And the result of that is that European actors are showing an indifference to the pain and suffering that they are experiencing as a result of pushback and pullback policies. And so one of the main arguments in this paper is conceptualizing how states can engage in cruelty at a distance. And in particular, how states can engage in cruelty without showing a specific intent to harm. So when people think about cruelty in general, they tend to think about individuals engaging in the infliction of pain and suffering upon other people, sometimes for the pleasure of that particular act. But cruelty can also be exercised without a specific intent to harm, or the exercise of pleasure, for example, of harming others. And it can be shown by showing an indifference to the harm that is being inflicted upon another person. And so when we look at pushbacks and pullbacks, we're not seeing European actors specifically intending to deport people or push and pull back people to Libya with a specific intention for them to be tortured or ill-treated. But rather what we're seeing is that the consequence of pushbacks and pullbacks is that people are being pushed back and detained in inhumane detention centres and tortured. But European actors are showing an indifference to the consequences of their actions. And so when we understand this idea that cruelty can be exercised with indifference as well, we can also start to look at how cruelty can be exercised from a distance, and in particular through bureaucratic policies and laws. And so working and building upon the work of Arendt and Bormann, I argue that it's through the construction of international laws and the creation of particular policies like pushbacks and pullbacks that is enabling European actors to engage in cruelty at a distance. Because although they may not be in Libya themselves, inflicting pain and suffering upon individuals, the consequences of their policies are that they are resulting in the infliction of pain and suffering. And so what we see, again, with the infliction of cruelty at a distance is that as psychological and physical distance occurs from the implementation of policy and the consequences of that policy on the ground, we see also a removal of responsibility, both moral and legal, that helps to create this indifference to human suffering that European actors are showing at the moment to the suffering of refugees and migrants in Libya. And so to elaborate on how states can exercise cruelty at a distance, I talk about how through legal evasion, states can construct, and other international actors can construct vulnerability through their policies. And so the torture and ill treatment is the side effect of European policies of pushbacks and pullbacks. This is the consequence of what's happening now as people are returning or people are being pushed back and pulled back to Libya in particular. As the legal evasion weakens human rights protections, it exacerbates and distributes vulnerability to migrants and refugees, and so increases the risk that they are going to be subjected to torture and ill treatment if they are returned to Libya. I then turn to and look at the main case study of my article, which is Italian pushbacks and pullbacks to Libya with EU financial and material support. And so I first look at the pushback operations and how since 2009 Italy engaged in pushbacks where they intercepted migrant vessels on the high seas in the Mediterranean Sea and pushed them back to Libya. Now, in order to enable Italy to do this, they had to strategically use international law to legitimize and justify their policies. So what they did was that they denied jurisdiction over migrants, they denied non-refoulement obligations, and they denied the opportunity for people to request asylum on the high seas. And so by stripping migrants and refugees of important human rights and refugee rights under international law, they were able to push people back into Libya. The result, as I show in the article, is that people were subjected to inhumane treatment and torture on their return. What I also do in this case study is look at how, despite the fact that the European Court of Human Rights found that pushbacks to be in contravention to the European Convention on Human Rights, what we see is that despite Italy seizing pushback operations after the European Court ruling, they started to implement what are called pullback operations, where Italy and the EU funded and provided material support to Libyan authorities so that Libyan authorities could intercept departing migrants and refugee vessels that were heading to Europe, intercept them and pull them back into Libya to prevent them from arriving on European shores. The result, as I show in the article, is that people were detained in inhumane detention conditions and they were often tortured as well. And so here I argue that this was an exercise of cruelty because in both cases, both pushbacks and pullbacks, European actors knew what were the results of their actions. They knew that if they returned people to Libya, there was a significant risk that they were going to be tortured or treated inhumanely. And yet they did it anyway. And the reason they did it was to achieve migration deterrence goals. So here we see a situation of states exercising cruelty at a distance. We see the use of bureaucratic rules and norms be strategically used and manipulated to enable particular policies that were resulting in the infliction of pain and suffering as people were being pushed and pulled back to Libya. And so the final part of my article looks at how we can challenge this type of cruelty at a distance, the use of bureaucratic rules and norms, and how they can result in inhumane treatment and, in particular, torture. Well, I argue that despite the fact that European actors have been using international law strategically to justify pushbacks and pullbacks, I also argue that international law can be used to challenge this cruelty and also to expand moral boundaries. The reason being is that, again, if we look at the court ruling under the European Court of Human Rights that resulted in pushbacks seizing by Italy, what we see in that case is that international law was able to stop a particular policy. And so here we see international law can offer hope. It can offer an opportunity to stop policies from occurring and stop harm from occurring as well. It can also expand moral boundaries and legal protections, as the European Court of Human Rights case showed that Italy had human rights obligations to people even on the high seas. However, although we should have hope that international law can help to ameliorate suffering in world politics, what we also need to do is exercise a bit of caution and realize that states are going to continue to try to evade their legal obligations. They're going to continue to try to evade international law in order to be able to implement the policies that they want. And so this is going to be a constant cat and mouse type of game where states try to shape and reshape international law in response to court rulings, and then the court rulings are going to have to respond to that use of creative, strategic use of international law. So there's the kind of cautious but also optimistic note that my article leaves on. Thanks very much, everyone, for watching the presentation. I hope you've enjoyed the presentation, and I hope you enjoy reading the article as well. Thanks again to Review of International Studies for publishing this piece, and also for offering me the opportunity to deliver this presentation. Thanks a lot.